worked for 27 years as an organizer and international rep for the communication workers in New England. Unlike several of the folks on the panel, I'm a non-practicing lawyer of long standing, and somehow had the silly idea back in the early 1980s that I should go to law school and learn something about labor law. That might be a helpful pursuit for someone interested in getting involved with unions and workers' rights. And yeah, I've dealt with the National Labor Relations Board, as I'm sure some people in this room have. How many people have ever dealt with the NLRB in their capacity as a worker or organizer or union rep? Okay, we have some other experienced users of, attempted users of the NLRB. So I'm going to talk a little bit about kind of my own recent union organizing experience, what kind of the objective basis for this Employee Free Choice Act campaign that Brother Dennis Surratt, who's still on active duty at CWA, is going to talk more about. I just want to say that I agree very much with the kind of broader, more radical perspective that you just got from Jim Pope and the work that he and Peter Kelman and Ed Bruno have done, trying to kind of reframe this whole issue and suggest an alternative strategy, kind of better rooted in history, one based on the 13th Amendment. I'm in total agreement with that, and fully support their efforts, and think this article that they have in the forthcoming issue of Manny's Journal, Working USA, is a terrific statement of that. Unfortunately, that's not, I think as Jim acknowledged, where the kind of bulk of the mainstream labor movement is, for better or worse. So I want to talk a little bit about why the labor movement's where it's at on this issue of labor law reform as it's being framed more narrowly and pursued as a major union priority, supposedly, during this presidential election circus, and as a #1 legislative priority if the control of Congress shifts to the Democrats and there's a Democrat in the White House as of next January. The CWA has been often identified as one of the few unions more committed to organizing. It has been involved over the last 10, 15 years in what's called the bargaining to organize strategy, where we've tried to bypass the traditional NLRB representation election mechanism for workers in the private sector getting organized, and through negotiations of private agreements with employers, tried to create an alternative to that. The shorthand, which most people are familiar with, is card check neutrality. The concept is that workers ought to be able to, a majority in an appropriate unit, sign up unionization authorization cards, and that the employer ought to be compelled to recognize the union. Based on those, the employer ought to butt out of the decision to unionize. And of course, the basis for this Employee Free Choice Act is that this ought to be codified, that unions shouldn't have to negotiate this kind of recognition procedure with individual employers in a lot of different industries. This procedure ought to be kind of mandatory. Employers ought to be required to recognize newly created bargaining units based on this card check process, card signing, rather than forcing unions and workers to the second stage that they currently have to get engaged in now, the representation election, which the employer contests, in which unions tend to lose for all the reasons that Jim just mentioned in terms of the unlevel playing field and the employer tactics and so forth. In CWA, we were able to get major companies like AT&T, even Verizon, in regards to a certain portion of his workforce, Lucent, the wireless division of AT&T, now known as AT&T Mobility, to agree to card check and neutrality procedures. The last 10 years that I worked with the union in New England, our telecom locals up there were able to organize 5,000 workers through these procedures in manufacturing and wireless call centers, customer service rep jobs at Verizon, in wireless retail stores, small groups of salespeople for Singular, now AT&T Mobility phones. I can tell you that based on my bargain to organize experience in the private sector with contested NLRB elections, we would not have organized probably 500 of those 5,000 workers if we had to do it the old way, the hard way, the way that employers still prefer, which is the contested NRLB election group. So those unions, SEIU, Unite, HERE, CWA, whatever other ones have pursued this, have definitely been able to make membership gains through neutralizing employer interference, using their leverage, what remains of it in collective bargaining relationships, to establish this other recognition process, to bypass the board, and to improve their win rates and enable more workers to exercise their right to join, form a union without harassment and retaliatory firings and propaganda campaigns and so forth, to create kind of public sector conditions. There's a lot of organizing going on in the public sector today, mainly with home-based workers and newly created public employee bargaining units around the country. And unions involved in that, including CWA and SEIU and AFSCME and AFT, been able to organize in the last 4 or 5 years over 500,000 home-based workers who are independent contractors. But because it's the public sector, because there's no employer interference, because they've gotten bargaining orders, executive orders and legislation creating these new units from friendly legislators and governors, tremendous surge of organizing. If you could have those public sector conditions in the private sector, there would certainly be a lot more private sector union membership growth than there is right now with this tremendous weight of employer interference. So you can see, as much as the theory that Jim laid out is attractive in terms of better framing of this, that the unions that have been involved in these card check and neutrality-based organizing rights, organizing efforts, that has fed into a revived campaign, which is different than 30 years ago. I had a little experience with that in 1977, 78, where the focus to some degree was on some of the same issues, increasing penalties and speeding up board elections, but the card check piece really wasn't part of it in the failed labor law reform effort of the Carter era. One interesting thing that we could get into here, and it's been much in the news lately for people who follow this stuff, is that there is a downside to card check-based campaign. Jim talked about staff domination of the organizing process. There's been a tendency to push this issue of organizing rights deals in a direction of what you might call kind of company union arrangements, where certain unions have decided that they're willing to offer any quid pro quos to an employer who agrees to roll out the red carpet for them to come in, give them access, give them an employee list, give them the opportunity to sign people up and recognize the union on that basis. And the quid pro quo involves basically rolling over in collective bargaining, giving up the right to strike, giving up the right to be a patient advocate, having a cut and dried first contract at pretty low standards. And there's quite a raging debate about that right now, and people who are interested in that topic, I suggest you bring it up during the question period and get into it further. That is definitely a downside, and some people on the left are opposed to the Employee Free Choice Act because they think that'll promote more of that if the framework for these private agreements is incorporated in federal private sector labor law. But clearly something has got to be done. When I first got involved in the labor movement, 20 to 25% of the workforce was unionized. It's down to half that right now overall, heading towards 7% in the private sector. And, it is a structural problem, as Jim and others have pointed out. It's not a question of are the Democrats in with friendlier appointees on the NRLB or the Republicans in. If you look at the period 1977 to 2001, the Republicans and the Democrats were in about an equal amount of time during that period. And whether it was a Bush board or a Clinton board or a Carter board, the downward spiral of union density continued unabated. So clearly the problem requires a change in the law, not just appointing some more union-friendly people to the board positions and staff positions in D.C. And that's why I think, as Dennis is going to indicate, there is a major mobilization underway in the CWA and the AFL-CIO to get more union members behind this push for passing the Employee Free Choice Act, the highlights of which are in your packets. Sorry we didn't have enough for everybody.
Are they all gone?
We didn't expect so much interest in this topic. You'll have to share. I could make extras for anybody that doesn't have one. And there's some sample propaganda from CWA about framing this issue. as a larger rights issue, and the AFL-CIO resolution that Dennis is going to talk about. Thank you.
I just want to introduce Dennis Surratt once again, if I may.
A working class hero is something to be.